no-fault system in New York is one of the most misunderstood, most manipulated, and dare I say it, most abused systems in the state. The harsh reality is it's not designed to protect you. It is built to protect the insurance companies, and it works against you. In this video, I'm going to explain what no-fault is, how it works, and how you, if you are injured in a car accident in New York State, can protect yourself. My name is Phil Rizzuto, and I've been handling car accident cases for over 30 years. We represent clients throughout all 5 boroughs in New York City. That means Manhattan, Brooklyn, Bronx, Queens, and even Staten Island, all over Long Island, Westchester, and beyond. So here's the basic concept behind no-fault. No-fault insurance means that if you are in a car accident, your insurance company will pay for your medical treatment, your lost wages, and certain out-of-pocket expenses, regardless of who's at fault for the accident. That sounds great, doesn't it? But here's the catch. You only have 30 days from the date of the accident to file an application for no-fault benefits. Your benefits are then capped at $50,000 unless you buy additional personal injury protection, which is called PIP. In addition, you can't sue for personal injuries unless you sustain what the law defines as a serious injury. To add insult to injury, the insurance company has the right to conduct an examination of you with the doctors they choose in order to determine whether your medical treatment is medically necessary. When no-fault came into effect in the 70s, the concept behind it was to pay for your medical expenses if you were injured in a car accident, regardless of whose fault the accident is. So if you hit somebody in the rear and you were injured, your insurance company would pay for your benefits. That's called first-party benefits. This is also known as personal injury protection, or PIP. It will pay for reasonable and necessary medical expenses. It will pay for a percentage of your lost wages, but it's capped at $2,000 a month, and it will pay for your transportation to and from your doctors for treatment. It will pay for household help, and it will pay for other reasonable and necessary expenses, but it's capped at $25 per day, and it's only good for a year. Now there's more. If you die, your estate gets a death benefit of $2,000 under the no-fault law. Now the insurance companies will spin this. They are doing a great kindness and benevolent service to you out of the kindness of their big hearts. The reality is insurance companies do not like to pay on claims, whether they're responsible to or not, whether it's needed or not. They do not want to pay on your claim, and they will do everything in their power to avoid paying it. So here's an example. Originally, when this law was enacted, the individual injured in a car accident had 90 days to file an application for no-fault benefit. That time period has been reduced to 30 days. You only have 30 days from the date of the accident to file an application for no-fault benefits. If you don't, your benefits will be denied. You won't even get benefit. Another thing the insurance companies can do is have you examined by doctors they hire to determine if your treatment is reasonable and necessary. And the insurance companies have the power to pay on claims or not pay on claims. And if they deem your treatment not medically necessary, they will deny your claim and they will not pay it. And guess who's responsible? Guess who's responsible for paying for medical treatment that the insurance company will not pay? You. So let's go back for a minute and just think about this. In the past, you had 90 days to file an application for no-fault benefits. The insurance company cut that down to 30 days. The insurance company has the right to send you to their doctor to determine if your treatment is medically necessary. Now, under the old system, when you had 90 days to file an application for medical benefits, that means you got to go for more treatment until the insurance company decided, hey, we're going to send you to the doctor. Now, under the current system, where you have 30 days to file an application for no-fault benefits, the insurance company is sending you to their doctors sooner than you would have had. So now, in a lot of situations, the insurance company is sending you to their doctors to be examined to determine if they should continue to pay for your medical treatment before the time in which you previously had to even file an application for no-fault benefits. Let that sink in for a minute. Now, another thing the insurance companies did when they went to help you, when they implemented this insurance law, is they said, we're going to pay for all of your benefits, all of your treatment. If you're injured in a car accident, regardless of whose fault the accident is. But in order to bring a claim, personal injuries against the other vehicle, you have to sustain what the law defines as a serious injury. It's under Section 5102D of the New York State Insurance Law. And in order to sue for personal injuries and pain and suffering, you have to be able to prove you sustained a significant injury, which is defined as death, loss of a limb, loss of a fetus, significant disfigurement, a fracture, or a permanent injury, significant limitation of use of a body function or system, or a medically determined injury that impairs your usual and customary daily activities for 90 out of 180 days immediately following the accident. That means if a doctor says you cannot do what you normally do on a daily basis, that would qualify. But if you're injured and you don't go to a doctor and you say, I can't go to work for 3 months following the accident, that doesn't count. You need to have a doctor render you disabled for 90 out of 180 days immediately following the accident. Same with any of the other categories. A doctor has to confirm you have a fracture. A doctor has to determine that your injuries are permanent. Your doctor has to determine that you have a significant limitation of a body function or system. If you have a disfigurement, if you have a scar, the insurance company can argue it's not significant. So we need a doctor to determine that the disfigurement is significant, because the insurance company is going to hire a doctor to say it isn't. Now, regardless of what category you may fall under, the insurance company will most likely fight it. I've seen insurance companies argue death is not related, that the fracture is an old fracture, that it was not caused by the accident, that the significant is not significant, that your injuries are not permanent. Everything you're claiming was pre-existing. They go into claim it was not caused by the accident. If you have a significant limitation, they're going to argue it's not significant or it wasn't caused by the accident. So the moral of the story is you need to hire an attorney who knows what they're doing to protect your rights. So some of the things you can do to protect your rights immediately is get medical treatment. If in doubt, if you are shaken up, go to the doctor, go to the emergency room, go to an urgent care, but get treatment to get checked out so it's documented. Because I know a lot of people that are in a car accident, they have aches and pains and they think they're gonna get over it, and then it gets worse, and they say, I'm not the type to sue, I'm not litigious, it'll get better, and they wait several days, several weeks, and then they go to the doctor, and the insurance company will say, they didn't go to the hospital right after the accident. They didn't call EMS. They didn't go to the ER. It can't be related. Even if you don't go through in an ambulance, get treatment if you think you are injured or shaken up, just so it's documented. And it's covered under no fault. No fault will pay for that treatment. Your worst case scenario or your best case scenario is you weren't actually injured and you've gone to the hospital and you've gotten checked out and it turns out you're better. That's okay. But if you're not okay and you are injured, it's going to hurt your case. Another thing you should do if you are in a car accident and you think you are remotely injured, after you go get checked out or even before you go get medical treatment, file the application for no-fault benefits. Again, an attorney will help you. They should not charge you to file an application for no-fault benefits. I know attorneys that do it. I hate it. I don't think they should do it. I think it should be a service that is offered to clients, and we get paid on a contingency fee basis. So whether we get paid or not, find an attorney that will help you and at least guide you through filling out your no-fault application. We do it for people regardless if we're going to take your case or not. If we sign up the case and we decide we're not pursuing it, we will never charge you to file an application for no-fault benefits. But find an attorney that will do the same thing and not charge you, because if you do not file the application within 30 days, you're done. They will not pay for your treatment. And if you then go for treatment after the time period, it's harder to prove that the injuries are related because the insurance company will say the injuries are not related because you didn't get medical treatment right away. And they look to see how much no-fault paid for your medical treatment when evaluating cases. So in a car accident, and you don't fill out the application for no-fault benefits, and you don't bill the treatment under no-fault, the insurance company is going to argue It's not related because no fault didn't pay anything. And you may have been thinking you're doing the right thing and you're not a litigious person and you don't want to take advantage of the system that is taking advantage of you. They will turn around and they will screw you. Now, once you start getting treatment, in order to prove you sustained a serious injury as defined under the law, you need medical documentation. The medical documentation has to support it. And again, regardless of whatever category you're in, the insurance company is going to fight it, especially when you get into the categories that are not so obvious. They will fight the obvious categories, but when you're claiming you have a permanent injury or a significant limitation or a medically determined injury that impairs your usual and customary daily activities for 90 out of 180 days, they're going to fight it harder, and it is harder to prove. So you need the medical documentation in order to do this. If you stop treating because you feel that treatment isn't helping, I feel pain, it helps a little bit, but after a few days, it's back. Once you stop, your case is essentially over. Your pain and suffering is limited up to the time when you stop. And if you go back to the doctor after a significant period of time, they call that a gap in treatment. And a judge could dismiss your case because you don't have enough medical documentation to support your claim, to support that you sustained a serious injury, to support that the injuries are permanent, to support that the injuries are causing you a significant limitation. It is crucial to your case that you continue to get treatment. So there is medical documentation to support it. And if the case has to go to trial, your doctor can come in and testify regarding the treatment you received and what the extent of your injuries are. Now, if you found this information helpful, like the video, subscribe to the channel, and if you have any questions regarding car accidents or any personal injury matters whatsoever, ring Rizzuto. We can help. 855-RIZZUTO, and I'll see you next time.